So if I sign a publishing deal, does that come with admin publishing kind of built in, or do I have to find an admin publisher in addition to the publishing contract?
Admin is just like publishing light. It's like a type of publishing deal, but it doesn't come with all the bells and whistles.
Got it.
So you got your standard base model publishing agreement
Yeah.
that's going to get you A to B.
Yeah.
Like they're going to collect your
Mhm.
royalties for you. They're going to file your copyright registrations for you. They're going to issue licenses for people who request them. That's about it.
Hello, everybody. Welcome to another season 2 of the Vana Room. And we are in our contract series with a couple of these episodes. And right now, this is Publishing Deals Part 2, with the one and only Mrs. Davey Jay Esquire. Hello, Miss Davey.
Hello, Miss Monique.
Thank you so much. I know you have a jam-packed schedule, so we are just going to dive right in. So this is our second interview with you about the types of publishing deals that are out there. And today we want to talk about admin deals or administration deals. Do they have any other name other than admin deal or administration deal?
I mean, potato, that's pretty much what people say, though. You never know. Like there's all sorts of times when I get agreements that the title of the contract is not what people generally refer to the deal as. I mean, it's just like a pet. You have like a name for your pet, and then you eventually never call them that name. You wind up giving them all sorts of other names too. So I mean, and at the end of the day, like the title of the document isn't really the important part.
Okay.
Because there's generally even a clause in there that says like the headings and titles in this agreement don't have anything to do with the interpretation of this agreement.
I would assume admin deals don't get as cute as pet names. Like you don't have people calling admin deals my little stinky, do you?
I mean, to be fair, I had one client who let me off the leash, as long as we're staying with the pet analogy, who totally let me off the leash and was like, go ahead and have as much fun with it as you want.
Nice.
And I made each section of the contract like a different like line of lyrics or reference to a performer or a song or something, or, a musical event. So that I can, I actually did that. It took me 10 times longer than it should have.
But you had fun.
But I had so much fun with it. So.
Yes.
I love it. All right. So admin deals. Can you talk about the basic structure of what an admin deal would typically cover?
So generally an administration deal with publishing is really kind of just like what it sounds like. They're handling the administrative side of your music publishing. So we're not looking at like big marketing push. We're not looking at like actively shopping the music. We're looking at somebody who really enjoys Excel spreadsheets and handling all of that fun for you. So handling all the ins and outs of the royalties with your music and making sure that all of those various royalty streams from different areas, different exploitations of your music, that those are all accounted for and collected and then filter over to you. And so in general, with your administration deal, what we're looking at is that it's going to be a lower royalty share or lower percentage that they take because they're not doing as much work, quite honestly. So it doesn't justify, doing like a traditional music publishing deal is going to be like a 50-50 split. That's very, very standard, is that the songwriters share and half of it, the publishing company takes the other half of it. It's what we call the writer's share and the publisher's share. And so, we'll see like a lesser amount taken if it's an admin deal. Sometimes I see something like 25% to the publisher instead of the 50%. And then just quick note, in case somebody's joining us for the first time with this particular podcast, and it can be super confusing, but we refer to 100% of the writer's share of publishing and 100% of the publisher's share of publishing. So technically one song is 200%. And, like that can make people's heads explode. Just accept it. Accept that the pie is a 200% pie. It's an extra large pie, right? So, but that's what we say is 100% of writer share and 100% of publishers share, which can get a little confusing sometimes when people are, filling out their BMI or ASCAP registrations or whatnot. So just be aware of that.
You mentioned that they get
a minute.
What's that?
Can I digress for a quick minute because it's the new year? And
Absolutely.
is there something important that just changed this year?
Yes,
do you know what it
the
is,
mechanical.
Monique?
Yes.
Yes,
the CRB
rate
passing.
has changed.
The mechanical rate has changed.
Big news, big win.
Yep.
Yes,
I had to redo all the math on my assignments. I wasn't really happy about it, but
yes. So it's gone up for the first time since we were all young and beautiful.
What is it? 14 years now? It's been 14 years, right?
I think it was 2008 or 2008, was it?
Something like, I think it was like 2008 or 2000. Yeah, something like that.
Yeah.
But it's been like 14 years.
Yeah. And when you think about it, like, look at what 2008, 2009 money could buy you.
Mm-hmm.
And then try and buy a dozen eggs today. Like that.
Right. You stole my joke.
Making an omelet or anything. Like, that's just an ostentatious display of wealth.
Listen, I know that's right.
But, now it's the mechanical rate has increased to 12 cents, which is up from 9.1 cents per copy distributed. So that's a pretty decent increase. It's a third.
As it should.
Pretty much, Yeah, for sure. So, long overdue increase to songwriters now. So you guys should be seeing a bump in your next royalty statement. So that should be, coming in for the exploitations starting January 1st of 2023 is when this new rate kicked in.
Mm-hmm. Awesome. With the admin deal, you mentioned that the publisher will take a smaller percentage. Is there also a fee typically attached to an admin deal as well?
Not necessarily. In general, I'm not a huge fan of publishing agreements with fees upfront because most publishers, their compensation comes from the fact that they are doing the work, and then so it gives them incentive to do that work. You know what I mean? So certainly if you're getting paid a percentage of the money that comes in, you're going to want to make sure you're getting all the money that's supposed to come in. Because that impacts your bottom line. So I get inherently, I don't know if I want to say the word suspicious, but I'm just like, why are you charging money up front? And fun fact, it's the same from music publishing to literary publishing, as far as no upfront fees because you're getting a share of the revenue that's coming in. And when they do charge an upfront fee, it concerns me. And that's when we get out the magnifying glass. And I look very, very closely at, not that I don't anyways, but at every word in that deal. And then we do a deep dive on who is this publisher? What is their track record? Who have they worked with? What do we know about them? How long have they been around? To try and see if there is some justification for that. Because quite the contrary, rather than the songwriter paying a fee for that, like sometimes they can get an advance on their royalties. So just like, with any other type of deal, depending on your status and your track record, as far as like what you've written that makes money, you might be able to get an advance.
Something I don't think we brought up before, but I kind of want to ask it now, as it may or may not relate to this type of deal. In recording contracts, there's usually something called a control composition clause, correct?
Yeah.
Or control copyright, sorry, something like that.
Control composition, you're right.
Okay. Can you, A, explain what that means, and B, is that something we would expect to see in a publishing deal, specifically an admin deal, since that's what we're talking about?
Okay, yeah. So a controlled compositions clause in a recording agreement. So first we have to understand that with music, you've got the two separate copyrights. There's a copyright in your musical work, which is the publishing, which is what we're talking about. And then there's the copyright in the sound recording. right? So that's the actual recorded version of the composition and lyrics. So a lot of times the recording agreement will have a controlled composition clause that deals with the payment of this mechanical royalty that we were talking about, for the record label to distribute recordings, because the label will wind up owning the sound recordings by virtue of the work for hire clause in the recording agreement, but they still don't have the right to reproduce and distribute copies of that musical work, of the composition and lyrics, because they don't own that part. Even though it's their artist signed to their label, if that artist is the songwriter, then they've got a separate publisher over here who's handling those exploitations. So in the controlled compositions clause, what it does is limit how much the record label has to pay for those mechanical licenses. It puts a cap on it. Sometimes it waives it in part. So with a very standard recording agreement, we'll see it that the controlled compositions clause says they're only going to pay mechanicals on 10 songs an album, regardless of how many songs are on an album. So if you release an album with 15 songs on it, they're only paying mechanicals for 10. They're only paying that flat rate of which is now 12 cents. They're not going to pay the per minute rate for longer songs, which winds up being a little bit more money for the longer songs. So they're capping it in that way too. And then sometimes with the less standard, but way more indie, we're all kind of broke and trying to do the best we can side of a recording agreement, that kind of deal. Sometimes we'll see it, and sometimes with a little bit bigger organizations too, we'll see a full waiver of mechanicals on the first album, perhaps, or something like that, because they'll just be like, hey, we're a low budget label and we don't have a ton of money either, and we can't afford to, pay for recording and distribution and marketing and pay you mechanical as well. So sometimes if it's a really like a bootstrapping situation, sometimes we see that also. So that's what the controlled compositions clause does, meaning that the rights to the composition is controlled by the artist, right? So that's why we call it a controlled composition.
So in relationship to an admin deal, because my understanding is that in an administration deal, you don't have to give up any rights. So then is this clause not found in these types of deals then?
I'm not sure. With an administration deal, it's generally that's dealing with your publishing stuff.
Right.
So it wouldn't necessarily have that. It wouldn't say there wouldn't be a controlled compositions clause in your admin deal because you're not paying your admin publisher any of that.
Okay.
What you're doing is notifying your publisher like, hey, my recording agreement says that there's a limitation or a cap on mechanicals. So when my label accounts to you, expect the numbers not to be what they really should be.
Okay. So you still need to let that publisher know what you agreed to in your recording contract.
Right. Okay. And it's not going to shock them in the least. They're not going to be even the smallest bit surprised that there's a controlled compositions clause in there, because it's a pretty common thing to see.
So to my point, in an admin deal, unlike some of the other deals we may discuss in this series, you do not have to give up rights in this type of deal. In other words, I maintain the rights to my song, and if Lennon comes to me and wants to license it, I can do that and just give him whoever my contact person is over at the publishing company to handle the paperwork.
Yeah. So, are you talking about like exclusivity as far as that goes?
Just in an admin deal in general, do I have to have an exclusive admin deal? Is that a requirement? How does that work?
You're usually exclusive. It makes it difficult in execution if they're non-exclusive, because you have multiple companies trying to track down the royalties for certain work. So generally, as far as exclusivity goes, for a certain song or catalog, they're going to be exclusive, but perhaps not for everything you've done as a songwriter. Okay. You know what I mean? So like you might have other works that are with a different publishing company, And that's fine because that other publishing company is the one that's tracking the royalties for those and collecting those. Whereas maybe you've got an admin deal for some old past, some old back catalog stuff. And then in that case, the company that's doing your admin stuff would be exclusive for those particular songs.
So what would determine, now that you bring it up, because I don't know that we brought this up before, but I love that you just brought up that point, which is you don't have to have all of your songs with one particular publishing company. So under what circumstances would I break up my catalog for different publishing companies?
Well, sure. There could be a number of reasons. One might be less of your choice and more of the publisher's offer. They might be like, we want to work on, we want to be the publisher for this album or for these songs, or just moving forward and not your back catalog at all. So that's entirely possible. Or it might be that you entered into some single song agreements, which single song agreements are really just for either individual songs or, despite the name, a handful of like cherry picked identified songs. Like the publisher is going to exploit these particular songs, but that leaves the rest of everything, for you to affiliate with a different publisher. So it's kind of like those are going to be your common situations as to how you're going to be sort of here, there, and everywhere with a publisher. So it'd be nice to be able to be like, yeah, this is my publisher, and it's, like it's just me and them. But it's commonly not the case because, even if you do sign an exclusive songwriting agreement with a certain publishing company, that has a term. And so when the term ends, just expires in the normal course of things, if you don't sign with them again, then you're off to another publishing company. So that publisher you were with would continue to exploit the rights in those songs that you delivered during the term of your agreement with them. But you go and sign a new publishing, agreement with publisher B, and publisher B is going to exploit all of those new works. So you're going to have your catalog spread across different publishers throughout the course of your career.
Thank you. So for publishing deals, are admin publishing deals built into publishing contracts? And then admin deals are not built in, will not come with a publishing agreement? Because I'm getting, it's a little bit confusing for the difference between a publishing and then admin publishing. So if I sign a publishing deal, does that come with admin publishing kind of built in, or do I have to find an admin publisher in addition to the publishing contract?
So admin is just like publishing light.
Okay.
It's like a type of publishing deal, but it doesn't come with all the bells and whistles.
Got it.
So you got your standard base model publishing agreement.
Yeah.
That's going to get you A to B. Yeah. They're going to collect your royalties for you. They're going to file your copyright registrations for you. They're going to issue licenses for people who request them. That's about it. There's no marketing component to that. They're not shopping anything for you. They're not out there going like, hey, who should be, songwriter of the year is Lennon. Like we're really going to push for him, they're not doing any of that. They're just really think of them as an accounting centric publishing deal without the marketing department.
Okay.
So it's a publishing agreement. It's just limited in what services you get.
Got it.
And so, these are more appropriate frequently for people who do not need the push. So there are some people whose catalogs are of a certain type that they just don't need the marketing, or they are established at a certain level where they just don't need it. And so in those instances, what they then do is have an admin deal, and then that way less of their money goes to the publishing expense, to the share that's taken by the publishing company, because they don't need those additional services, so they don't pay for them. So that's why for those people, you'd have an admin deal. I have not had a lot of clients with admin deals. I've had a couple, but by and large, a lot of my clients will go for a more traditional publishing deal because they prefer to have the full suite of services rather than just the limited, amount that an admin deal offers them.
But that also means they're giving up more percentage of the royalty in those situations.
Yeah, for the traditional publishing deal, yeah.
Yeah. Yeah.
Yeah, then it goes, to your standard like 50-50.
50-50. What is the term typically on, and like which like the minimum term, I guess, on these types of deals?
Usually they like to negotiate. They like to offer they will do like an initial period of a couple of years and then have option periods for extensions, that follow it. So usually we'll see something like that. Uh, so it's in my experience, if you're working with a reputable publisher, they're always pretty reasonable about stuff. I've had clients who we've like renegotiated their publishing deal in the middle of the deal, like in the middle of the contract, and been like, hey, this is what's going on. Here's some of the things that the clients have done recently, and we'd like to revisit the contract and see what we can do to kind of, adjust in light of the fact that this was their status when they signed and this is their status now. And in my experience, the publishers have not been anything but open to talking about that. And sometimes we actually do get some modifications done to reflect that change in status, because at the end of the day, they do want their songwriters to be happy too. They don't want them to be, feel like they're locked to them, and that they're miserable and that sort of thing. So they do want them to be happy, and they want everybody to, get along and make money and make music and all that good stuff. So that's what I've seen too. Even though we've got a certain term, sometimes these things we can negotiate during the middle of it.
So for the beginners out there, can we just do a pros and cons? And we can start with the pros. Like, what are some positive things to look for in your agreement? If you can just think of like your top 3, like, okay, this is the sign of a good contract or a good potential relationship. So maybe like your top 3 pros and your top 3 cons.
It's going to sound a little crazy and counterintuitive, but it's got to be long. If it's a long, and I mean like the actual length of the agreement, not the term of how many years. I mean the actual how many pages. Because I know a lot of people will be like, oh, it's just a short agreement, it can't be that bad. No, that's usually worse. The reason why it's usually worse is because there's all sorts of stuff that's not covered. There's things you haven't been talking about. There are things that we haven't addressed. And those are the things that we're going to argue about later. And there are certain things that can't be done with like just a word or two. We need a couple sentences or a couple of paragraphs to fully explain it. Like, I have seen contracts where it didn't say when somebody was getting paid. It just never, wouldn't you like to know? Like, aside from how much am I getting paid, isn't the next question usually when do I get paid?
Yeah.
So I've seen contracts be silent on that and be all sorts of manner of things. So generally, just from a quick, hey, how do I know if this is good, bad, or ugly? The length is generally, the longer it is, generally the better it is. No, obviously that's not always the case, but generally. So there's that. The second thing, what's generally good? Approvals. So with publishing agreements in general, you're giving the publisher the right to license out your song for, uses by third parties for whatever they want to do with it. There should be, and if there's not, you need to add something that says in there, a clause that's kind of like, it's an approvals clause that says, if the use is in connection with one of these types of things, then we need to talk to you and get further approval from you in writing before we can give permission, before we issue this license. So generally it's things like alcohol, tobacco, firearms, pharmaceuticals, personal hygiene products, political causes, charitable causes, and then, anything that you feel very strongly or passionately for or against or whatever, like say you just, I don't know, you absolutely hate turtles. You know, like, and you're like, under no circumstances will my music be used in association with turtles. You know, like, so that you would want to make sure that's in there, so that way they can't just issue the license and then suddenly,
Mhm.
you know, your music is being used in affiliation with a certain clause,
Mhm.
or with a certain, you know, animal.
Mhm.
So so there's that. So that's another thing, is to look for things like that. Um, Other things to look for, aside from, you know, a lot of times clarity shouldn't be that difficult. Like, a well-written contract doesn't have to be confusing. Um, you should be able to get a good gist of, you know, good understanding just reading it. Like, yes, there might be stuff where you're like, okay, that kind of seems like legal gobbledygook. That stuff's usually closer to the back at the bottom of the contract, because that's where we put in like all of our magic words to make the contract work better for you. Um, but generally, throughout the rest of it, it should be pretty straightforward. Like, you know, you're going to deliver so many songs. Here are the songs. Here's when you get
Mhm.
paid. Here's how often you get paid. Here's, you know what I mean? Like, here's the percentage you get paid.
Mhm.
So that it's very clear, you know, like, so there should be it should be very straightforward as far as stuff like that goes. Most of the time, when my clients get a contract that they say was really confusing and they couldn't understand it, it's because the contract was a word salad.
Mhm.
Like, somebody just, like, Frankensteined something together,
Mhm.
and it didn't make any sense, and in this paragraph, it called you the artist, and the next paragraph, it started calling you the writer, and then in the next paragraph, you did, like, you know what I mean? Like, it was just, like, a mishmash of stuff with
Mhm.
sentences that don't make sense in any language. Like, sometimes that's why. Like, it's not because you don't understand legalese, it's because the actual document has been hacked up so badly that it's not even recognizable as English anymore.
Mhm.
So, like, don't fault yourself. So
Mhm.
if there's, you know, an obscene amount of, you know, lack of clarity in there, then it might be indicative of a huge problem overall.
Mhm. What about, is it possible? This may be a silly question, but is it possible for a publishing agreement to be overreaching?
Oh yeah,
Okay.
absolutely. So generally what we see with overreach, one is that lack of an approvals clause. To me, like, that's a huge thing. Like, that should always be there. It should be, you know, right out the gate, it should be in the contract. But if it's not, most publishers are like, yeah, go ahead and put it in. The other thing is, name, image, and likeness uses. You
Hmm.
want to make sure, because certainly you need to give them permission to use your name, voice, likeness, image in
Mhm.
connection with the music and to market your music and things like that. But, you know, you want to make sure that, the uses are really restricted to what's necessary, and that, you know, they can't just willy nilly do whatever they want with your name, likeness, image. So yeah, so there's that too. Um, you know, so I've seen a few where, and even particularly lately, I've seen a few where I've just been like, oh, you know, this is a bit too much. Like, they're, you know, running a little hog wild with these, and I don't think that's necessary for them to do what they want to do or need to do.
And the reason I'm asking this question is because there are a number of instances here in the music industry where some artists have been in brutal fights with their publishing company over the rights to their songs. And I'm like, how does this happen? Right? There's a famous dispute. I don't know necessarily if it's famous, but you have someone like Armin Baladian, who I'm going to call by name, um, who was managing the rights for George Clinton. And George Clinton spent years fighting with this man to get his rights back from his publishing. So, how do they even get in these situations? Are reversion clause now standard in publishing?
I mean, almost universally, they get into these situations because they signed something that wasn't good in the beginning.
Hmm.
You know, and
So they
unfortunately, a
didn't
lot.
look for these red flags that we're talking about here.
Right. And, and to be clear, the red flags aren't restrained only to the document. Like, again, like I said before, like I look into who the other party is, like how long have they been
Mm-hmm.
around? Who do they work with? Like,
Mm-hmm.
do they dot their I's and cross their T's? Because if they're not doing it for themselves, what makes you think they're going to do it for you? And that's
Mm-hmm.
my biggest thing is, people tend to watch out for themselves more so than they will anybody else. So if they're
Sure.
not taking care of themselves, so anyway, so that's usually the case is that it started off poorly. Like he signed something you shouldn't have signed because you can't
Mm-hmm.
transfer your copyright ownership without it being in writing and signed. It has to be clear that you're doing that in the document. Now, whether he had read it, whether he did read it but didn't understand it, or anything else, unfortunately, is wholly irrelevant when it comes to enforceability. If you signed it, you signed it.
Mm-hmm.
You can't later say, well, I didn't read it or I didn't understand it. Because if you didn't read it and you didn't understand it, you shouldn't have signed it because you were agreeing to it, whatever it said when you did. So that's really kind of where things start to go awry. Not enough people take the time to have a professional look over their contracts and explain them. And then that's how we wind up. And it's the thing is that they think like, oh, well, I don't want to spend the money to have somebody look this over. That's expensive. I can do other things with this money. But then, a couple of years down the road, if all's going according to plan, this is your career and this is how you're making all of your money. And you're making, tens of
Mm-hmm.
thousands of dollars a year, if not hundreds of thousands of dollars a year. But you're, now, at this point when you're making that much money, it would seem like a no-brainer. Like, oh yeah, I'd spend a couple $100 to have somebody tell me what was going on with this. But back then you know what I mean? Like it seemed disproportionately large. But when you think of it in the big picture of what's the value of this music catalog, it's absolutely worth every penny you spend to get some good
Mm-hmm.
advice. Because,
Mm-hmm.
in some situations, yeah, this is a lifelong plus commitment. Because in some types of publishing deals, it's forever. You're transferring rights over to this publishing company and you don't get them back. You'll get your royalties, but you're not going to get your rights back. So there's that. As far as reversion clauses go, it's something to negotiate for. It's something where I've certainly, what I recommend most commonly reversion clauses is if I've got an artist who's working with a new company, a smaller company, low budget, that sort of thing. That's my biggest concern is we need to make sure that if the exploitation of your music doesn't generate enough revenue or we don't see an increase in the revenue generated, or if this company you're signing up with files for bankruptcy or reorganization or any number of other things that are indicative of the fact that they're crumbling,
Mm-hmm.
then there's the reversion clause in there that you get your rights back. Because the worst thing
Mm-hmm.
that could happen is if this company goes into bankruptcy, or if they just close, then what? I mean,
Mm-hmm.
you don't automatically get your copyrights back, because those rights that the publisher acquires are an asset just like any other asset. So it's not like the desk that was in their office is suddenly yours, like, so,
Mm-hmm.
your copyright's much the same way. So it's not magically reverted to you, because the company closed. And that's where a lot of music rights wind up getting lost. They get very lost in the shuffle because companies fold, they get bought out, they get transferred.
Mm-hmm.
And, I've dealt with companies, huge companies that they don't even know what they own. Like, oh, I didn't realize we owned this. And I'm like, well, based on what I can find from the paper trail, it seems like it stopped with you, but you guys might want to inventory your own stuff. So yeah, so that can get real messy. So that's why I always insist on a reversion clause for situations like that when there could potentially be,
Mm-hmm.
bankruptcy, or if they, file for dissolution.
Wow. Yeah, that's a whole another deep conversation we can have for sure. And when we get to recording contracts, I definitely want to talk about something you brought up, which is something we've been seeing, which is people saying, oh, they signed me to a bad contract, or I was only 17 or 18, or, when I got into that record deal. Now I'm 30 and this is a bad, and I don't want to, blend everything all in this conversation because Lord knows I could. But when we get to recording contracts, I definitely want to talk about that aspect that you brought up. Is there anything, before we let you go, is there anything pertinent to not just publishing deals, but maybe particularly an administrative deal that you feel needs to be communicated that we didn't talk about? And if it's general to publishing, feel free to throw that in there.
I would just I would say to always make sure you're clear about what's going on with the rights to each particular song you work on, because a lot of times I'll see people like, oh yeah, I worked with this person on this song, but they didn't do that much. And I'm like, did they sign something? Did you guys have split sheets? Yeah. Work for hire or anything? Like, did they, so a lot of times people will just they'll be dismissive about other people's contributions, which could be a huge problem later on, because you have to understand, and this goes for publishing as well as recording agreements, there's always going to be a clause in there that says that you basically, to paraphrase, you pinky swear that nothing you do is going to get them sued. Well, if you aren't, if you misrepresent, who the contributors, that's an easy word, isn't it? Really good one. Contributors, who the writers were, the writers were on those songs, then, if they later get sued because this person's like, hey, you owe me money because I wrote that song too, and I haven't seen any royalties, and what are you doing with my music, et cetera, you're going to be responsible for all of those fees that publishing company has to pay, and their legal fees, and if court costs, God forbid, like all of that, you'll be responsible for it in the indemnification clause in your agreement. So you always want to be like really crystal clear about what's going on with the rights to each and every song that you create, because once it moves from your hands through the stream, it acquires liability. Like you're picking up liability for what happens all the way down the road, from, the publisher to the distributor to the label to the, you know what I mean? Like, and so on and so forth. And if you, get a sync license and it's in a movie, then, you're also liable to the film producer and the studio and all of that stuff. So you want to be really clear about, what's going on with the rights to each one of those songs, and make sure that, you have everything tied up neatly with a bow on it. Have people sign their split sheets, have people sign work for hire agreements, make sure, it's all clear in black and white who owns what as far as the song goes.
Awesome. Well, thank you again. And as always, we will see this beautiful lady again because she is our local queen of all things music law. And you can find Davey's website for her law firm is Mealy & Jay. They are a Central Florida based, specifically Orlando based law firm, but you guys do cover areas that you don't necessarily have to be in Florida.
Right.
So
yeah, it just depends on what the needs are. Some of my clients are all around the world, and other times I can't help. It just depends on what the issue is, so jurisdictions persnickety like that.
But you guys are fantastic, and again, we totally appreciate you. We will always support Mealy & Jay because you guys always do right by us, and just love you to death. So thank you, Davey. Thank you, Lennon. Thank you for watching the Vana Room Season 2, and we will be back with more on contracts. Make sure you guys check us out every Monday. Thank you.
Bye.